what we've learned in the course of the last 72 hours, maybe a little bit more, is that this defendant was simply driving down the street and saw the victim, had no prior interaction or contact with the victim, and spontaneously decided to pull his car over, much of this occurring on camera, follow her from some distance around the downtown area, and then attack her. This was a brutal attack. The victim broke her jaw. The victim had broken teeth. The victim is in and out of consciousness, still in very serious condition at the hospital, largely unable to communicate. And sadly, this was also a pretty vicious rape. The defendant stayed on scene, covered in blood, told people his name, his first name only, and pretended to be someone who was helping the victim. Before police arrived, he did run off. So for a course of a couple of days, police obviously scoured the city for video, finding video eventually of the defendant's car driving in certain areas, which matched up to a traffic stop that occurred and was recorded by body camera. And all in all, it was conclusive that it was the defendant. That's been even made more conclusive by the fact that the defendant's DNA was taken, and it has been confirmed that is his DNA on the victim that was recovered in the sexual assault kit. In addition to that, the defendant was interviewed and largely admitted to the vast majority of the allegations here in the criminal complaint. When it comes to the sexual assault, he claimed somewhat of a lack of recollection or that he might have done it. But I will tell the court that my review of the evidence so far, and especially the biological evidence, it will be conclusively proven that it was him who did the sexual assault. All in all, this is a case in which you have someone who's going to likely spend the remainder of their life in the state prison system. Prior to Act 3, that'd be the type of case that anyone in my position would have asked for $500,000 or $1 million bail, just given the incentive to flee, even with someone with no criminal record, which is the defendant. Post Act 3, the court has some additional considerations that you should take into account. One is there a reasonable basis to believe that bail is necessary to assure his appearance in court, and whether there is an act of violent crime and that the public needs to be protected from. Here, there are 3 violent crimes that have been alleged, and I cannot imagine the public needing more protection from anyone but this defendant in this specific case. We live in a community where thousands of young people just moved to our city, thousands of young women. They should be free to walk around the downtown area without fear of being followed, attacked, and raped. We live in a city, of course, where people routinely are walking around without that fear. And unfortunately, that fear is now present in everyone's mind, and that's because of the defendant. The spontaneous nature in which he picked a victim, the lack of any motivation for this crime previously with the victim, is especially concerning. If he is to be free, everyone is at risk of this spontaneously happening again. I see no choice but the court to impose such a very high amount of cash bail that it would be close to impossible, but not impossible for someone to post it. The idea being many people would likely have to put up most of their life savings in order to take a bet on getting the defendant out of jail. If there was an ability for the state to, with any sort of logistical possibility, hold the defendant without bail, this is the type of case where that would happen. There is a statute in Wisconsin dealing with preventative detention, and I think it's appropriate to address because I'm asking for a higher amount of cash bail than my office would normally ask for in any case. Wisconsin's preventative detention statute is never used by any prosecutor, as far as I'm aware, almost anywhere in the state. I've been prosecuting cases in most of the most serious cases in this county for the better part of a decade, and I've never been able to use it. And I think the public who's probably tuning into this and wondering why someone in this defendant's shoes is eligible for bail should understand that in Wisconsin, the preventative detention statute would require us to essentially have a mini trial within 10 days, meaning the victim could possibly and likely be subpoenaed by the defense to testify within those 10 days, meaning sometime next week or the week after. This victim is still in the hospital, still in very critical condition. So when people talk about there being the ability in Wisconsin to hold someone without cash bail, it's on paper only. No one in their right mind in my shoes would agree that a sexual assault victim who was raped just 3 days ago should be forced into testimony within the next 10 days while she's still unable to communicate in the hospital. That hearing would have to take place every 60 days until the defendant's trial. It's an unworkable, unpractical statute that should be re-examined by the legislature and the voters at some point because it is in our Constitution. But what we have is Act 3. Act 3 happened this year. The voters recently approved it, and they said to commissioners in your shoes and courts that exist throughout the state that you should take the public's protection into account when setting bail. This is a case in which you should do exactly that. And that's why I'm asking for such a high amount. At this point, as to conditions of bail, I'm asking that the defendant, if he were to post this any amount of cash bail, that he be subject to the bail monitoring program, that he have a GPS affixed to his ankle before he's released from the Dane County Jail. If he were to post bail during off hours, that he not be released until the GPS unit was able to be placed on his ankle. I'm asking that before he be released, there be a hearing to determine a residence in which he would be confined to home detention other than for court appearances and emergencies only. Right now, to protect the anonymity of the victim and her family, I'm not specifically asking for a no contact, so I don't have to disclose their names.
All right. And Attorney Bell, your position on bail.
Thank you, Your Honor. I'll start by saying we have no objection to the non-monetary conditions that the state has proposed at this point. Regarding cash bail, we also agree that cash bail is appropriate. However, we vastly differ on what the amount should be. We are asking that the court consider the amount of $10,000. Well, that is certainly not the impossible number that the state proposes. That is actually still quite a large amount of money for someone in their 20s. And Mr. Thompson is 26. He is a college graduate. He has no criminal record whatsoever. He does have ties to this community. He has parents and siblings and other family members who live in Dane County, and he himself is a resident of Dane County. At this time, we are obviously just beginning our investigation of the matter. I can inform the court that at this point, even this early in our investigation, we have uncovered some evidence that is inconsistent with the state's narrative. While we do understand that the court can and should consider public safety, as the state has very well articulated, there is a statute if the court wishes to, if the state wishes to hold the defendant without bail, which is constructively what he is asking the court to do in this case. While public safety absolutely is a consideration, and we do understand that there is a campus community in fear here, $10,000 is the appropriate amount to protect the safety of the public in this case and to move forward with this case in the matter of justice.
All right, thank you. And Attorney Brown, your response?
No, obviously, I disagree. $10,000 is frankly not that much money for a lot of people, especially someone like the defendant who up until his arrest had a job, has a college degree, seemed to be a normal guy. That's partially what makes this crime even more terrifying for everyone involved. And I don't know why, but to some extent it does, that he appeared to fit in so well, a normal person living in our community, living, breathing, walking amongst us, who was able to do something so horrendous. But he was a very normal person who I believe could come up with a very normal amount of money. And I don't believe that would serve as any incentive whatsoever to show up for court. I think anyone who can read this criminal complaint, and obviously you just did, and I know counsel just did, and I've had perhaps more time to digest these facts, but no reasonable person could read this complaint and think that he will be out of prison anytime within the next several decades if he's convicted of what's alleged in this complaint. And obviously there's an incentive to flee there that's so high that even prior to Act 3, $10,000 would have been woefully insufficient. Certainly post Act 3, when the court can actually consider the protection of public and not have to, as we used to have to do in these rooms, kind of hide behind the idea of fleeing and exposure and try to make arguments based on that. I think we can all be very honest and just say that this man is perhaps our greatest public safety threat that lives in this county right now. And that's deserving of a significant amount of cash bail. And that amount isn't $10,000 in my estimation.
And what do you know about his prior record, if any? Because I don't have the benefit of a PSA.
None. He has had a couple traffic stops in his life from what I'm aware of, but he has no criminal record whatsoever.
I should allow you to respond.
Well, I find it interesting that counsel has just stated that he's been making arguments for the last several years that were dishonest, but regardless, I have acknowledged that I do believe that public safety is an issue that the court can consider. Again, $10,000 cash is an amount that is substantial for someone in their 20s. The state is correct that there is no criminal history here. there's no known motive here. And as I stated, we are even in the early phases of our investigation finding inconsistencies within the state's stories. This is before we have received any of police reports or any of the other evidence. Bail should be an amount to secure the appearance of the defendant. It should be in the amount to secure the safety of the public. But it's inappropriate to make it such that it could never possibly be paid by the person. That's not what protects the safety of the public.
All right, thank you. Well, I have to set bail, and Attorney Brown's talked about that. I think there are two charges here that are eligible for preventative detention, but it is a cumbersome statute, and I'm not aware of anybody in the state ever pursuing it because of how difficult it is, and actually would require potential testimony by the victim, because I don't think like the preliminary hearing statutes allow hearsay. So the state kind of has to have a mini trial. It's not like a preliminary hearing. So while it's available to them, I understand why they have elected not to proceed with that. So I have to set a bail. Under the old law, we'd be looking at risk to appear. That would be the only analysis. I wouldn't get to take into consideration protection of the public and use cash bail to do that. Obviously, the voters in Wisconsin disagreed with that and elected or voted for Act 3, which allows the court to take that into consideration when there are charges that are eligible, which the defendant has charges that are eligible here. If we were here on a DC, given no prior record and some ties as outlined by Attorney Bell, I think everybody would probably agree this is probably a signature bond case. That's not what we're looking at here. I don't think a minimal cash bail would be appropriate to assure appearance in court, given the nature of the charges. It's always hard for me to know what a judge is going to do at sentencing, but it seems pretty clear to me if convicted of these charges, it would be a significant sentence. Is it going to be the rest of his life, as Attorney Brown posits? I don't know, but I don't think something in the decades is unreasonable to think could be a reasonable sentence by a judge if convicted. There's a lot of incentive not to appear for that, just under the old standard of risk not to appear in court. I think I set bail well in excess of that. The very few other random sex assault cases that have come before me. Thankfully, we don't have a lot of those in Dane County, but they have come through time to time. And I think I've set, tens of thousands of dollars because I think the likely sentence is such that it provides a great incentive not to appear and requires significant cash bail to assure appearance. Here, we're also dealing with Act 3. I need to take into consideration the totality of the circumstances. One of those is the prior record and any prior violent convictions, which is the reason I asked that question. I need to take into consideration intimidation of the victim or witnesses. I don't know that that's readily apparent based upon what I've seen in the four corners of the criminal complaint. And risk to appear, which I think is pretty great at this point, given what he's facing. And the charges at this point, and that's what I'm looking at, is the four corners of the criminal complaint, and you'll have an opportunity for a preliminary hearing to explore the sufficiency of the state's evidence and the strength of that. It looks pretty strong. I don't know if I would call it a confession, but there are multiple statements that are highly incriminating, suggesting that the defendant is the one that committed this offense. There are other statements of inconsistencies with the physical evidence that suggest he was not a bystander and was the person who actually assaulted this victim. And I guess the manner of where he then admittedly drug her to, it seems to suggest that it wasn't a more public location. It was a less public location, which is more consistent with guilt. Today, I hear that there's DNA on the victim. I think depends where that is as to how strong that is, given that he admits that he had contact with her. There's some video evidence suggesting he was following the victim. So I think the state's case is really strong. And again, I'm just looking at what I've got in the four corners of the criminal complaint. So again, I think that suggests a strong incentive not to appear in court. When I look at the nature of the charges and what's alleged here, the violence is just shocking. It's appalling. I don't know that I need to comment as to whether I think this is the worst sex assault I've ever seen. Obviously, I've seen too many of them over the last 23 years, but it is extremely concerning behavior, and it's random behavior. So it concerns me. This isn't a situation where pretrial services can really do a great job of protecting the public at large. While it can do a pretty good job in protecting particular victims because we can order somebody not to be in a particular location and have contact with somebody, I don't think it does it here. What the state has asked for is a significant bail. Quite frankly, I think higher bail than most homicides that I've ever seen come through the court in the past 23 years, not all of them. But almost all of them, with a few exceptions, and higher than I think any bail's been set on a homicide since Act 3. And if Attorney Brown knows different, he can correct me. I'm obviously not here every day. That is a significant bail. I think it's excessive, but I think $10,000 is also not sufficient at all to assure appearance in court, and it's not sufficient at all to protect the public. There needs to be a substantial bail that, if posted, is something that people are not going to want to lose, and they're essentially acting as de facto pretrial services to ensure Mr. Thompson is in compliance with the bail conditions, and this sort of thing never happens again. It's just such concerning behavior. I think it has to be significant. I guess I struggle with setting it beyond what's ever been set in most homicide cases. I'm not going to do that, but I'm going to set $1 million cash bail because I don't think the public can be protected without a very significant cash bail that any sort of benefactor who may be extremely rich isn't going to want to have forfeited if there's a bail violation. I will order pretrial services if that's posted, and I will order GPS be equipped at the jail so there's no release prior to that, and adopt the other conditions that there be a bail hearing prior to his release if the bail is posted, to address where he's going to reside. Any other potential conditions, as I understand, that was all stipulated to. I want to check with the clerk if she needs any clarification on the pretrial services order. And I think there's a list. Val, should we get this scheduled for a timely preliminary hearing?
We will be waiving time limits, Your Honor.
Set a status, and we'll check to make sure that works with your calendar. For now, should we use the jail as a mailing address?
Yes, please.
All right.
I'm sorry.
Yes. Waive time limits, if you can let them know when we can do a status.
At 1:40. 1:40, that will work.